Okay, I'll bring in Mr. Masum Billah. Do you want to state your interest in this particular subject matter mainly?
Thanks very much. Thanks very much, Dr. Molik. Such a privilege to find myself on the same panel with Paulo Casaca. Thank you very much. Well, my motivation and interest for international criminal law has both historical, legal, and personal dimensions. Look at this history that one jurist from the then East Pakistan, Mr. Justice Radha Vinod Paul, was a judge of the Tokyo Tribunal, and his dissenting opinion has been very famous, widely quoted and studied. So when I came across as a law academic his dissenting opinion, that attracted me much about, to know more about this branch of international law. That's one. Second, as a nation, we have this 1971. We are a war-torn country. We carry the trauma of history. And it's very interesting to note that Bangladesh is the first country in the world to enact a domestic law, International Crimes Tribunal Act 1973, in the post-independence setting. Right, the first reflections of the Nuremberg principles, of the Tokyo principles. But unfortunately, due to the then contemporary political, geopolitical reasons, the tribunal could not have functioned. It was only in 2009 that the tribunal got revived through the mandate of the people. So in order to meet the requirement of history, to ensure justice for the victims of 1971, Bangladesh and arguably all international community owed this just cause's responsibility to ensure justice for the victims. So as a law academic, that matter also interests me. Thirdly, it is with a mixed feeling that the very political party in Bangladesh, which championed the justice process of 1971, is under the legal scrutiny now by the same process. So this is an irony of history and travesty of fate. And that also needs attention, that whether it has at all reversed the total picture and scenario, and to what extent the glory of Bangladesh's contribution to the international criminal law that has made previously is now being, whether is at risk. So as a law academic, I am interested to see that to what extent Bangladesh is still making herself relevant to the corpus of international criminal law, like crimes against humanity, genocide law, and etc. So it's fine to see your country being so relevant and uttered in the area of the trial of international criminal law, but at the same time, it is disheartening to see that Bangladesh is struggling to meet the requirements of international justice, fairness, and due process. Thanks very much.
Yes. So, we have mentioned now about I guess, what happened historically. Is it coming into play in what's happening now? And is it a reversal, as Masum also mentioned, of what happened in this very courts to seek justice from 1971 happening and the genocide then? So what is it? The ICT laws were amended in this process of trial this time. Just who would want to?
Do you want me to address this?
Yes, go ahead. Yeah, because you
Okay.
did touch on it, so we will.
Just I will take you back a bit to the history. The International Crimes Tribunal has major three stages of its development. One is I have just mentioned 1973, the year when the law was actually enacted, but the tribunal was not set up per se.
No.
Second stage is in 2009,
2000, yeah.
actually 2010, when Bangladesh fulfilled its commitment and brought all the auxiliary forces known as Razakars, Al-Badrs, and Al-Shams, who were local collaborators to the Pakistani army. They were brought to justice. And third stage is 2024, soon after the 5th August change, the 1973 law was actually changed very controversially by presidential ordinance to executive whim four times, and majority of them was to change the idea of presumption of innocence. If you are even named in the charge, you are being sacked from any position and you are ineligible to contest in the election. That's number one. Second, politically targeted amendments like targeting Awami League or targeting Sheikh Hasina or the intelligence members who worked with the then Prime Minister. So some amendments has been made to implicate the targeted groups. Fourthly, the threshold of crimes against humanity or the elements of crimes against humanity has been changed, apparently inserting the concept of widespread and systematic attack, but at the same time, very cleverly maintaining the standard that in case of any inconsistency with the ICC statute, the Bangladesh provision will prevail. And most controversially, changing the scope of the law. Previously, it was only for the 1971 crimes. Now it has extended its area of application to the July incidents. So these are some most controversial amendments that has been made by the interim government, which takes us back to the root of the very proceedings, which is probably one of the reasons why the title of today's discussion has been so made. So, before starting any discussion about the trial itself, about the questions of due process itself, let us not forget that 4 times the law has been changed at the whim of the executive authority who are unelected.
That's it.
And whose whole legal structure they are breathing in is controversial. It is not that much constitutional. Is founded on very controversial principles of constitutionality. So that based on this nullity, this tribunal has been reconstituted and formed. Probably it is not the same tribunal which was actually contemplated by the forefathers, by our framers of 1973 law.
Let's go back to fair trial. So can you maybe Masum can start us off with what constitutes a fair trial, and why are they concerns?
At the outset, let me be very clear that the July incidents and atrocities must be brought to justice.
Of course, yes.
And full comprehensive accountability must be ensured, but not at the cost of due process and fair trial.
Indeed. That's not doing justice then, is it?
Right, exactly. Now, international criminal law, which is being reflected in the 1973 Act, right? The role of this law is to play Portia. I mean, you can take blood from my body. You can take flesh, but please take care that no blood shed. So that's the role of due process, criminal trial. Now, what is fair trial that has been well defined and recognized by domestic law and international law as well? The treaty law, the human rights law, humanitarian law, customary international law. They have recognized that right to fair trial is a fundamental human right. And arguably, this has enjoyed the status of just causes principles. For the readers, I further clarify it for our viewers. It has culminated into a peremptory norms of international law, where no derogation is permissible. I mean, the state parties, or even the states who are no parties to the major international instruments, cannot put this excuse that, well, we are not obligated to follow the standard of due process, fairness. The fairness which has been clearly mentioned by Article 14 of the International Covenant on Civil and Political Rights, acronymed as ICCPR. There are 13 rights which fall within the domain of due process rights or fair trial rights. To name a few, Bablin, one is right to be tried by a competent, note this word, competent, independent, and impartial tribunal. Will you tell me that the tribunal in Bangladesh is competent, where none of the judges were a judge at all? None of the judges are trained in international criminal law. One of the retired judges who was actually took retirement in 2019 has only the experience of doing civil law and normal domestic penal law, has been just for the sake of this politically motivated trial, was appointed as the High Court Division as a probationary judge. Soon after appointing him, after 1 week, he was given the charge of the chairmanship of the tribunal. Can you imagine it? Is this a competent tribunal? And what about independence and impartial? I mean, I will give you some example how this tribunal has compromised the principles of independence and impartiality. Like, second requirement of fair trial is the accused must know what is the allegation, must know the charges, and must be able to give ample opportunity to prepare her case, to defend herself. Right to counsel, right to be tried without any undue delay. That does not mean that it should be in a hurry, in a month time, in a week time. I mean, the other day it was, the charge was framed, and now today you have come up with a verdict of death sentence, and death sentence of a public figure who has a 40 years of public political life. So that's another thing. To be present or not to be tried in absentia, then examining the witnesses, right to remain silent, right to equality, right to appeal. You know what the law in Bangladesh currently as it is, and if you are being tried in absentia, within 30 days you need to lodge an appeal to the appellate division. But if you are not absent, you lose the right to appeal. Now you tell me whether it fulfills the requirement of due process. And I can give you other names as well. What are the requirements required by international human rights law and international customary law, which has defined in no uncertain terms the standard of fairness. Now, back in Bangladesh, the Constitution of Bangladesh itself, in Article 31, has said that no person shall be deprived of life, liberty, body, property, reputation, save in accordance with law. So it has two aspects. One is substantive due process, another is procedural due process. Substantive due process demands that law itself should be fair. Now, I have just referred in my previous intervention that the law itself is unfair. It has been made unfair. So the substantive due process has been violated. Now, coming to the procedural due process, you will see that who has been the judges, who has done the investigations. The other day, I was listening over this, judgment reading out by the judges who was struggling to pronounce their own, judgments. Probably it is not written by themselves. I doubt it very much. Then what happened? They're saying, they are referring to the report of the OACHR. Now, let me tell you, this OACHR report in none of the places has confirmed that crimes against humanity has taken place. In page number 61, they have mentioned that to be sure that the crimes against humanity has taken place, further investigation is necessary by the competent authority.
That's
and
right.
who is that competent authority who has done this further crime? The OACR is not mandated by the Human Rights Council. Rather, they are commissioned by the Yunus government itself, who is a party to the conflict. Now, you see the violation of the natural justice principle that no man can be a judge of his own cause. So the very fundamental norms of justice has been violated. Now, trial in absentia, all the international standard established by the International Criminal Court or the ICTY, ICTR, or Sierra Leone, or Cambodia, whichever you mention, they have set the standard that, well, the person must be assertively, abandoning the right to appear, number one. Number two, there must be effective communication between the lawyer and the accused. And the law must ensure that upon reappearance, there must be a provision of retrial. The UK House of Lords in Moinuddin case even mentioned this. I refer these cases because these cases is frequently cited by the other side, the currently turned prosecutor who was a defense side lawyer previously, right? Now look at the prosecution team. As Paulo has rightly mentioned, that this person was defending the Jamaat Islam leaders. Now, the prosecutor are full of Jamaat Islam members. So this is a very, I'm an almost textual example of a politically motivated trial. And the chief prosecutor was seen at a procession where his political party, AB party, is demanding the banning of Awami League. And the judge, one of the judges, he was found to participate in a demonstration against Sheikh Hasina on 4th August. Look at the partiality standard and the impartial nature of the prosecution. So it is a politically vindicated trial, I should mention. The last hearing was on 30th November. The judgment date was 17th November. Now, Dr. Bablin, they have relied upon, on the short order, I am talking on the basis of the short order they have made. They just read out for the audience. They have referred to doctrine of joint criminal enterprise, Paulo. Joint criminal enterprise. Now, what is joint criminal enterprise? You know, it is a highly controversial doctrine. They have applied it into political question, and you must be aware that the initial enthusiasm about JCE faded long ago, and scholars doubt that its breadth has dominated over the debate, because this doctrine suffers from flaws like it blurs the line between intent and knowledge, extends the liability to unforeseeable acts to others, and it treats all participants as equally culpable regardless of their actual role. Now, if you applied it into a political context where a elected prime minister is trying to deal with the unruly mob, right? And you are applying joint criminal enterprise wrongly to a domestic setup. So this is a misapplication and misuse of international criminal law. I would argue, Dr. Bablin, that the principle of international criminal law has suffered a serious jolt into the hands of the Bangladeshi judges, Bangladeshi tribunal. And another doctrine they have relied, I'm sorry I'm taking much time in this.
It's important
please bear
points.
with me 1 or 2 minutes more.
Yes.
They have relied on command responsibility or superior responsibility, which is usually applied in war context, in conflict, in armed conflict context. So if you want to apply it to a political context in normal time, right, you must be very much aware of it. What is the evidence? The evidence is 3 audio tape record where the former prime minister is heard to talk over phone with a vice chancellor of a university. Look, a vice chancellor, a civilian person of a university, and 2 of his political colleagues. And what is the content? Content is that the fate the Jamaat Islam leaders embraced in the ICT tribunal, the same kind of fate will be to this new kind of militants. Now, apparently, this sentence of the so-called sentence, I'm not sure, it is not actually verified by their own way. It is not independently verified. Now, look at what is the culpability here. It is open to interpretation. Now, you are telling that using of drones, using of helicopters, or ordering the police officers to use lethal weapons, and you are interpreting as commanding responsibility. Such a dangerous argument. Because out of 1,400 people who died in the July incident, more than half of them has died after 5th August. So if Sheikh Hasina is culpably, criminally responsible for the deaths before 5th August, will you argue that Professor Yunus is criminally responsible for the post 5th August responsible on the basis of commanding responsibility? No political leader will be escaped, I think. So this has set a dangerous precedent. So this is also, once again, a very misapplication, because I did not actually find any, as a law academic, I was a keen observer of this judgment. They are referring that at Chankharpur, as a point of Dhaka city, some 6 people died. At Uttara or some other point, some more 6 people died. The Rangpur incident of infamous Abu Said incident, right? So all of these things, how is this related to the phone conversation with a Dhaka Varsity vice chancellor? Isn't it a very wrong and misplaced application of criminal? So you talk about application of law, you talk about observing the standard of fairness. Oh, I forgot to mention, they have relied about 60% of the total evidence on the testimony of the ex-IGP, Inspector General of Police, who has been an approver, who is an accomplice. Accomplice himself is an accused. Now, on the agreement reached between the state and the co-accused and the accomplice Abdullah Al-Mamun, that he is shown leniency, pardon, right? And just you have seen that he has been awarded 5-year death sentences. Probably that will also be pardoned sometimes later. Now, the international criminal law imposes a high threshold upon relying or believing on the testimony of an approver. It must be independently corroborated. Now, if on earth the prime minister orders the, IGP, the other member of the disciplinary committee, National Disciplinary Committee, must hear about it. Now, my question is whether other members of the National Core Committee has been consulted with before relying upon this concocted evidence. No? If that is not the whole judgment is a nullity.
Mm.
So I stop here. I can give you hundreds of
Plenty
examples.
more to think about, and you gave us lots actually. But doesn't interim government have any power in influencing and dismantling legal systems in a country? Masum, I don't know.
They promised to do so, but
Is it in the
in
constitution
order
to do
to
so?
legal reform is a big thing. It is something
Right.
like flattening corrugated iron with a hammer. It is that much difficult. Unless the legal culture, the people are prepared and taught about the nuances of legal niceties, any real reform cannot take place. Law cannot be revealed from upper position. That is the Austinian syndrome of law. Law is the command of the sovereign. It does not reflect the will of the people.
No.
So I'm pretty sure once the new government, elected government, if at all election takes place, I'm afraid that election is in an uncertain situation. If at all a true elected government is installed in Bangladesh, only they can decide about the fate of all these reforms. And I'm pretty sure majority of the ordinances, reforms done so far will not stand in the parliament, will not stand in the Supreme Court itself. Whole Supreme Court has been changed. The senior collegium of judges, they were unlawfully outthrown. The Chief Justice was outthrown. The judges were appointed without conformity to the Constitution. Now, you can easily imagine what is happening. Now, coming to, having said so, let me clarify this matter, that with the passage of time, over this 1.5 years by now, the whole design is very crystal clear. Even you might have observed that Miss Tilif Siddiq, the British MP's conviction,
That's right.
without any credible charges, is an extension of this political motivation. Because the target is that by hook or by crook, you abstain a particular political party and destroying their images, family members, and hold them in participating in the election, and thereby, barring the empowerment of the people of Bangladesh in the light of the spirit of 1971 and the founding principles of Bangladesh: nationalism, secularism, democracy, right, and socialism. Now, I also sense a kind of retribution, a display of retributionist approach within the judges themselves. You can remember when the trial was going on, a contempt petition was lodged against Sheikh Hasina, and the court found no time to award 6-month sentences in her absence, and shamelessly continued trying her, like violating the presumption of innocence doctrine. In the judgment, they are trying that we have decided to inflict death sentence. Now tell me, is inflicting death sentence is something to be decided, or it is something to be judicially exquisitely risked at based on the evidence and proof? This was not in this case. Now, surprisingly, Paolo will be surprised probably. The Volker Turk's unwanted comment in the publication ceremony, where Professor Yunus and Asif Nazrul was present, that crimes was against humanity had taken place, but the report itself does not say so. Now, the tribunal is referring to the sentence, to the utterance of Volker Turk as a reliance of their evidence. Does Volker Turk know it? Now, look at the international standard of justice. So I must argue, through you, Paolo, through the international community, that they must show an interest in Bangladesh's justice process and to encourage Bangladesh's government to hold this politically driven, trial of Sheikh Hasina and her colleagues. Let full-fledged justice be taken place, and for that, at the very outset, a free, fair, international, open, UN-sponsored, full-fledged investigation must take place for the 2024 July incidents. And only then the justice process can take place. Otherwise, the justice, this trial is not excellent. It has far-reaching consequences for Bangladesh. Number one, the political leaders like herself in future will be indicted. Number two, that absentia trial, the trend of absentia trial will be increased in many parts of the globe. Number three, that the political instability, both in Bangladesh, even regional instability, even its impact will be felt globally, because many people in Bangladesh has been persecuted and they have forced to leave the country, and they have created undue pressure, overwhelming pressure in the European migration phenomenon as well. And it will encourage the musical chair sitting of the justice system in Bangladesh. Even, Bablin, to my estimation, the ICT in Bangladesh did not follow Bangladesh has set previously. It has also compromised the very standard of Bangladesh, let alone international justice standard.